Welcome to another edition of the HR Hotline Live. I'm Chris DiPentima, the President and CEO of CBIA, and I want to welcome all of you and thank you for joining us this afternoon. I also want to thank Diane Mokriski for letting me crash her monthly webinar and inviting myself, and you'll hear from Vincent a little bit along. I thought it was important to just kind of kick us off as to why CBIA is still having this webinar, what's our position on certain things, and hopefully a little bit about what maybe you'll learn from us today. So, first and foremost, I'm fortunate to visit a lot of companies across the state of Connecticut, and I can tell you the number one thing I am asked about is vaccine mandates and how to encourage employees to get vaccinated so that we have safer workplaces. And while there is a federal lawsuit going on that I know Vincent and Diane will certainly talk about relative to the federal vaccine mandate, we've been continuing to encourage companies to plan as if that mandate will be going forward. We want our members to be well prepared in a good position when and if the mandate does happen, rather than be scrambling at the last minute, because this is not something you could turn on a switch. It takes up to 30 days for folks to get both shots in some cases. Businesses have to be thinking about what their policy is going to be. They should be finding from the rosters who is vaccinated and who's not vaccinated. So there's some planning that could be happening while this turmoil is happening at the federal level around the mandate itself. I also think it's important that you all are able to hear about what we're hearing from member companies about what they're doing around either a mandate or getting their employees vaccinated. And we're happy to share some of those stories with you today. We've actually recently posted an article of what two companies did to get to 100% vaccination level in two very different pathways. And so that's important for us to be able to share with you about what companies are doing relative to the vaccine mandate and what companies are doing to get some of their employees vaccinated so that they have a safer workplace so they can be as productive as possible. So while the federal lawsuit is happening, we've decided to continue forward with this webinar to educate you about the details behind the Osha requirements, to talk about some things you could be doing as the mandate is debated at the federal court, and to maybe give you some things to think about in your own businesses to encourage folks to get vaccinated, and also to have your businesses ready should the mandate come down. We've also been asked from companies about what is CBI doing relative to lobbying either against the mandate at the federal level or working with the state government to ensure any mandate that does happen isn't even more restrictive at the state level than what OSHA has come out with. First, let me just tell you, CBI, we don't lobby at a federal level. All of our policy is done at a state level. I can tell you, though, even if we did lobby at a federal level, in Connecticut, we have 7 members of the delegation, 5 representatives and 2 senators, who are very much aligned with President Biden. So any lobbying efforts that we would do at a federal level would really be in vain. It's very unlikely that our delegation would challenge the president with a mandate that he is really insisting on and believes in because he feels it will get more folks vaccinated across the country. But at that point, at the same time, we have been talking to the administration about what may happen in Connecticut should this mandate go forward. And we've been working really closely with Governor Lamont to make sure any regulations that come out in Connecticut are not more restrictive. I can tell you firsthand, the governor understands that businesses are being put in the middle of this mandate. We understand that at CBIA, put in the middle between the government and their employees, and we already have a labor shortage here in Connecticut. And the governor and many of the legislators don't want to make it more restrictive and have more of a stress on the labor participation. So while we're not lobbying at the federal level, we are certainly talking to the administration at the state level, and we'll continue to do so to make sure that any mandate that comes out is as least restrictive as possible for our businesses, so that we don't have any issues between the employers and the employees. So with that, I'll turn it over to Diane. That's some of the reasons why we decided to go forward with this webinar. I think you're going to learn a lot about the OSHA requirements, and along the way, we're happy to take any Q&A. So Diane, I'll turn it back to you.
All right, thank you very much. All right, so we're going to talk today about both the OSHA vaccine mandate and the federal contractor mandate. It's important to understand that those two things are different. And so Vincent Farisello is here from Carmody Torrance Sandak Hennessey. And so Vincent, why don't you share your screen, and we're just going to start with a very brief summary of the OSHA vaccine mandate, and then when we're done with that, we will move to questions. So Vincent, why don't you take it away?
Okay, just give me 1 second. I'm trying to fix my screen here. Do you guys see
Yep, I can see your first and second slides.
Okay, 1
Which
sec.
is fine, actually. The way you're showing it now is fine.
Okay, we'll just keep it that way, I guess. Well, anyway, good afternoon, everyone, and thanks to Chris and thanks to Diane and CBIA for having me, and thanks for putting this on, because I agree with Chris that it still is important to know this, because this especially the OSHA ETS can get revived at any given moment. For those who don't know me, my name is Vincent Farisello. I'm a partner at Carmody Torrance Sandak Hennessey, which is a general practice law firm with offices throughout Connecticut. I sit in Waterbury, but we also have offices in New Haven, Stamford, Litchfield, and a satellite, believe it or not, in Hartford. And I work in our labor and employment group, where we work primarily, frankly, almost exclusively with employers on all aspects of the employment relationship. I know we are scheduled to have a good sized group today, so I'm really excited and gonna just dig right in. 1 sec. All right, so today's session is not intended to, or it wasn't designed to be like a lecture, a long presentation in that way. Rather, it's designed to be interactive. What we really wanted to do was to have enough time to address all of your specific questions, because we know there's tons of them out there. But never, notwithstanding that, what I'd like to do is start, kind of start at the outset with a very brief overview of the rule, including which employers, which employees are covered, what are the general requirements, what are the consequences for non-compliance, and also we will talk a little bit about the status of the rule given the recent court action. And we're going to cover these general concepts to start pretty broadly. We'll be looking at it from sort of the proverbial 60,000 square foot view. But the real crux of this session, when we really want to get into the weeds and grapple with the nuances, is through the interactive Q&A session. And that's where I think we're really going to unpack the details, because as you all know, the devil's always in the details. So in September, President Biden announced that OSHA was developing an emergency temporary standard in response to the pandemic. In November, on November 5th, OSHA published the ETS. Now, just a little bit of background. What does an ETS mean? Well, OSHA has authority under the Occupational Safety and Health Act to issue an emergency temporary standard if it determines there is a grave danger that exists due to the exposure to or potential exposure to substances or agents determined to be toxic or physically harmful to employees. In those cases, typical rulemaking requirements, such as providing public notice and comment, isn't needed. And so OSHA has the authority in those circumstances to temporarily put in place a safety standard. And that's limited to no more than 6 months. And so the 6-month clock theoretically would have started when the rule was published back on November 5th. The stated purpose of the ETS is to minimize the risk of COVID transmission in the workplace, particularly with regard to those who are not vaccinated. And the most basic, the requirement that most people have heard of or are aware of is that covered employers must develop, implement, and enforce a policy that either, 1, mandates vaccination for all of their employees, or 2, allows regular COVID testing and mask wearing in lieu of vaccination. So who are covered employers? Essentially, it's private employers who have 100 or more employees, and that's counted on a firm-wide or corporate-wide basis. Now, there could be a lot of nuances in this, and so we can get really into the specifics on how to count the 100 employees during the Q&A, so I certainly encourage questions on that. So if those are the covered employers, who's not covered by the OSHA ETS? Well, any workplace that's covered under the federal contractor mandatory vaccination rules, because those workplaces are covered instead under the federal contractor rules, the executive order. And I'm, while this part of the presentation is going to focus on the OSHA stuff, I've worked with a ton of employees or employers who have to deal with the contractor issue, so we can certainly talk about that and answer questions about that too. One misconception I'll say about it though, and I heard this repeatedly from clients of mine. There's this misconception that the contractor rule only applies if you have a direct contract with the government, and that's just not the case. That the contractor rule also applies to subcontractors as well. So who else is not covered under the OSHA ETS? Also, workplaces providing healthcare or healthcare services or healthcare support services. They instead are covered under a separate CMS rule for Medicare participants. But one thing about that, I just saw in the news this morning that a circuit court or an appellate court in Missouri may have put a state enforcement of that rule as well, but I don't think that was on a national level. I think that one was just within the states covered by that appellate court. I don't know that for sure because that was late breaking news. In either case, both, you should realize that if you're covered under the CMS rule or the federal contractor rules, those rules are more stringent than the ETS too. So definitely pay attention to that. So with regard to employees, which employees are covered, obviously it would be any employee of a covered employer under the OSHA ETS rule, except for those who don't report to a workplace where other individuals are present, or for employees who are working from home, or for employees who work exclusively outdoors. And I'm going to stress the word exclusively, because other than just de minimis reasons to go indoors for very short de minimis periods of time, the word exclusively there is important because the job does need to primarily be done outdoors for it to be exempted. So the general requirements, we already covered one, which is that the covered employer needs to develop, implement, and enforce either a policy that requires vaccination for all employees, or that allows employees to choose between vaccination or weekly testing with mask wearing. And we can, of course, get into either of those during the Q&A in more detail. I want to spend a few minutes now going on some of the other requirements that get less headlines. One, and this one makes sense based on the first requirement, but it's important that employers will have to determine the vaccination status of each employee. And that includes maintaining a roster, a separate roster that includes all employees' vaccination status. It means obtaining acceptable proof of vaccination from vaccinated employees so that you can ensure that, that they have in fact been vaccinated. And it also includes a requirement to maintain records of employees' vaccination status to back up the information that's on that roster. Number three, the rule requires employers to provide certain paid time off for employees to get their vaccination doses. In those cases, employers are required to give at least, or up to, not at least, I should say, up to 4 hours of paid time to go get the vaccination dose. And that doesn't mean making them use their whatever PTO they have under your other policies. This up to 4 hours is separate and in addition to. It also requires employers to provide reasonable time off to employees to recover from the side effects, if any, from getting their doses. Some of the OSHA guidance said that they would accept up to 2 days of that kind of leave for dealing with the side effects to be reasonable. And in this case, separate than to get the vaccine, employers can require employees to use their sick time, if they have any, to deal with any side effects, for time off from side effects from getting the vaccine. And in either case, that paid time off would be paid. If it's to get the vaccine and it's that additional up to 4 hours pay, that's got to be paid at the employee's regular rate. Or if it's time off for side effects, then that will be at whatever the sick time is if you're having them use that. Number 4, ensure that unvaccinated employees test regularly. That means they have to do it at least weekly if they're working at all on site. So even if they're only working 1 day a week on site, they have to get the testing done weekly. If they're away from the workplace for more than a week or longer, then they need to get tested before they enter the workplace within 7 days before returning to the workplace. Number 5, you need to require prompt notification from employees of any positive test or other COVID diagnosis. And that's because number 6, you must immediately remove from the workplace any employee who tests positive and keep them out until they either meet the criteria under the CDC to discontinue home isolation, or they're given the okay to come back to work from their healthcare provider, or they subsequently test positive or negative for COVID. Doesn't have to be all 3, just one of those. 7th, the rule requires making unvaccinated employees wear masks whenever they're indoors. And there's a couple exceptions to that, which we can get into through the Q&A. But they also must be required to wear masks anytime they're in a vehicle with another person for work purposes. 8th, the rule requires employers to provide a bunch of different information to employees. That includes information about the ETS itself, any associated work policies that you've developed in connection with the ETS, information to employees about vaccine in general, including efficacy, safety issues, benefits of being vaccinated. I think in the guidance, they make reference to a specific CDC informational sheet that can help provide all of that information. You must provide employees information about their right to be free from retaliation or discrimination for, if they complain that you're not in compliance with the ETS. And it also mentions informing employees that there could be criminal penalties if they knowingly supply false statements or documents to you in connection with the ETS. And finally, there was a slight change in OSHA reporting requirements with regard to COVID. Now requires that any work-related COVID fatalities be reported to OSHA within 8 hours of the employer learning about it. And also any work-related COVID inpatient hospitalizations being reported to OSHA within 24 hours of the employer learning about it. One difficulty with that last requirement is it may not always be easy to determine whether the COVID diagnosis that results in death or hospitalization was actually caused or contracted from the workplace. But it is important to be mindful of that reporting requirement. So effective dates, most provisions intended to go into effect December 6th. But the vaccine/testing requirements, not until January 4th. And then on top of January 4th, a 2-week grace period for anyone who had received all doses on or before January 4th. And also note, and I mentioned this in the beginning about ETSs in general, intended to expire after 6 months, intended to be 6 months after November 5th. So consequences for a company that doesn't comply. I think this is really important. This is the attention grabber. Subject to penalties of up to nearly $14,000 per violation. And that $14,000 per violation can be assessed at OSHA's discretion, essentially. Could possibly be just based on each facility that's not in compliance, or it could be assessed for each area within a facility that's not in compliance, or it could be assessed based on each employee for whom within a facility that's not in compliance. Depending on how that gets added or stacked, that can add up really, really quickly. Should also note that Should this be revived, and should President Biden's Build Back Better program go into law? One of the proposals there is to significantly increase this penalty, not just for ETS purposes, but for OSHA purposes in general. On top of the standard penalties, OSHA can assess additional penalties if they find an employer was willful or egregiously failing to comply. That's at OSHA's discretion. And I bring that's an important piece, because during this period, while the ETS is on hold, if it does get revived and you're an employer out there who did nothing during this interim, and then this thing gets revived and the original deadlines are still in place, I think it's conceivable that OSHA could take the position you had all this time to plan, as Chris was talking about, or start getting ready for this, and you did nothing. So I think that's something for employers out there who are kind of at a crossroads of what to do, to keep in mind that may move the needle one way or the other. And then the last potential issue, if you are out there and don't comply, there's the potential for individual employee claims, not just things like whistleblower or retaliation type stuff, but it does beg the question: if this was in place and you were flouting it, you were not complying, you were ignoring it, does that mean that your failure to comply willfully exposed an employee to a hazard? Is that possibly the type of possibly the type of omission that could get past, for example, a workers, the general idea that under workers' comp, work-related injuries or illnesses, workers' comp is the exclusive remedy. Well, one of the exceptions to that is when an employer knowingly, purposely puts an employee in harm's way, knowing full well about that risk. So immediately following the publication of the rule, no surprise, lawsuits were filed across the country in a number of different districts. Opponents of the rule, including businesses, religious groups, civil rights type folks, they filed lawsuits in more conservative jurisdictions, but also, believe it or not, supporters of the rule filed lawsuits as well. One could argue that they were doing that so they could file the suits in more liberal districts in the hope of getting a more friendly response. And if you're asking yourself, what would they sue about if they support the rule? Well, to have a gripe, those lawsuits generally tended to say that the rule didn't go far enough. So you essentially had some lawsuits saying this goes too far, and then you had some lawsuits saying this doesn't go far enough. The conservative-leaning Fifth Circuit was first to the punch, though. They issued a temporary stay enjoining the rule on November 6th, only a day after the rule was published. And after expedited briefing and argument, the court extended that stay on November 12th. And it was kind of interesting. The court held that first, OSHA failed to meet that grave danger standard because in the court's view, the virus is widely present. It's widely present in the community, and it's not particular to most workplaces. And they also found that for the vast majority of employees out there, it's non-life-threatening. Now, the court wasn't saying it's not a life-threatening disease, just saying that for the vast majority of people who contract it, it won't be life-threatening. The other thing the court mentioned was, even if there was a grave danger, the applicability of this rule to only employees with 100 or more employees, employers with 100 or more employees, is both equally overbroad because it defines covered employers not by any actual threat of COVID transmission in a specific workplace. So it covers even employers, large employers, where the risk level is really low. So in that way, it's overbroad. But at the same time, the court held it's also under-inclusive, because if the stated purpose is to protect the most vulnerable of workers, it doesn't even do that for those vulnerable workers who work at an employer with less than 100 employees. So it seems that the court obviously had a lot of issues with the use of the grave danger standard, but also even if it was a grave danger, how the rule would apply. So I said there was a bunch of lawsuits filed all over the place. So pursuant to, there's a bunch of multi-district litigation rules to handle situations where there are multiple cases in multiple jurisdictions about the same topic. So because of those rules, all of the pending litigation, including the Fifth Circuit case, have now been consolidated. And following a random lottery drawing, the consolidated cases were assigned to the Sixth Circuit Court. The Sixth Circuit tends to be, like the Fifth Circuit, a little bit more conservative leaning. My numbers may not be exact here, but they're ballpark. There may be 21 judges in the Sixth Circuit, and maybe 15 have been appointed by Republican presidents and only 6 by Democrats. Either way, it's really hard to handicap what's going to happen. Obviously, the stay is still in place, but its permanence is obviously in play because the case is still pending. So again, hard to handicap. Courts sometimes surprise us, and we also don't know which of those 21 judges would be selected to hear the case anyway. Either way, I did hear that briefing is due by, I think, December 10th or so. So there certainly will not be any decision before then, and likely even after that. But regardless of the outcome, if the rule is revived or it's kept dead for the time being, it's very likely that the case will continue to the Supreme Court. And so I think we're a long way from having any definitive answers to what's going to happen. So with that, we're left with the $1 million question, which is what should employers do now? It's hard because, again, the rule can be brought back at any given moment and with those original deadlines. And to Chris's point, if you do nothing, you can get stuck. You can wind up in a position where you're scrambling. And so when you're grappling with the question of what should you do now, for some people, it's a balance between their culture, their values, and their risk tolerance. Because listen, at the end of the day, people feel really strongly on both sides of it, and on both sides for legitimate reasons. So I generally tend to, I have a lot of clients who tend to take Chris's point of view, to move forward, implement as if the order was still in place. Obviously the pro for that is that you'll be ready if and when this thing comes back alive. I've heard some employers who've taken that approach who have had to deal with some potential employee discontent. And of course, lots of folks, including us, we're all dealing with a tight labor market now. And so some employers out there are sensitive about doing something that could, really impact morale or the way employees feel. Another approach, and this is one that, I'm going to say it's an approach because some folks are doing it, but not one that I've generally been advising. And that's to do nothing and wait it out. Hold your fingers crossed that if it's revived, there's going to be a grace period or something. The pro to that is that it's an easy approach. There's less risk of upsetting employees because, like most of us, even our employees have very strong feelings on this on both sides. But I think the con here is, I think it sways me against this approach because if this rule is revived, especially without new deadlines, that risk of non-compliance is significant. The penalties we talked about are harsh, and I'm also would be nervous about the risk of being deemed to have a willful or egregious non-compliance. The third approach, and I've had some kind of do something like this, which is not implementing just yet, but communicating very openly with employees. Explain to employees what the ETS is, what the rule would require in broad brush strokes. Explain what those deadlines were and how there needs to be a 30-day buffer from, in most cases, from the beginning of the vaccination process to the end. Explain in simple terms what the status of the litigation is. Again, I think the misconception out there based on headlines is that this thing is completely dead and it's gone. Well, it's not. It could come back. I keep saying that because it can. And finally, explain that while we may not be implementing now, we nevertheless encourage you to get vaccinated, and maybe provide some educational material, explain the benefits of being prepared, maybe even offer a benefit like paid time off to encourage folks to get vaccinated. So then at least if this does come back, people have started the process or completed the process. But as you consider those various approaches, I strongly recommend doing a number of things right now. First, determine if you're covered under those contractor or healthcare rules, if you don't know that by now. Because if you are covered under one of those rules are still in effect. You still need to be moving forward with complying with those. Just the OSHA ETS, that's the only one that's been enjoined right now, subject to what I said a few minutes ago about CMS. But the federal contractor rules are certainly still in play. If you're not covered by one of those, learn as much as you can about the ETS requirements, including the fact that you're here learning about it. Consider doing some initial development design of a policy so it's ready if and when that's necessary. And also find out about your workplace. What numbers are you dealing with? Consider surveying employees about vaccination status. Obviously, being careful in doing that. Not getting into too many questions, just that the vac status itself, keeping that information confidential, but this will help you develop a risk profile for liability if the rule does come back. You certainly would want to know if this comes back and I'm only at 50% vax rate in my workplace, that's going to be moving a mountain to try to deal with that if we're put in a pinch. On the other hand, if you're pretty close to 100%, that's probably a different course of action that you might want to take based on that. And then, of course, look at your, look at yourself. Consider your company's risk profile. How averse are you to risk, and balance that with the probability of the law being revived. And I think it's important to work with Counsel or groups like CBIA to help make that decision. Me personally, I represent lots of employers. I'd be concerned that this thing does come back, and so the advice I'm giving is generally not to do nothing, but to either move forward as though it's going to go in place, or at least start communicating with employees. I think that's really, really important. So with that, I'm happy now to open it up to Diane. I'm sure ready to go with some Q&A and
Yep.
get into this. Is the fun part. This is the interesting stuff.
All right, so one thing I do want to, just to kind of piggyback on what you were saying about what you're recommending for your clients. See, and I think Chris mentioned this as well when we started. We do at CBIA, we also recommend that people start moving forward with this, even though it is currently on hold. And in particular, to move forward with what Vincent was just saying, doing the survey of your workforce, figuring out how many people are vaccinated, coming up with a plan, developing your policies. And as you can see, you just took it away, Vincent, can you? We're going to send out these slides, but that last slide has a link to the OSHA website. And there's a sample policy, that very first one, there's a sample policy there that you can start out with. And then you're going to want to tailor that to your business, but that's where you can get started, and you can contact Vincent for that to have it tailored to your specific business, but that'll get you started, because the first deadline that you're going to face if this does go into effect is the deadline having to do with when you have to have a policy, when you have to collect everyone's vaccine information, and when you have to distribute information. And a lot of that stuff, you have to, once this goes into effect, assuming it goes into effect, you have to be ready to provide that information to OSHA within 4 hours of their request. So you've got to have it ready. And that's of course not to say that OSHA is going to contact everybody in every state and say, give us immediately all your info, but you have to just kind of be aware of the fact that at any time, what's in effect, OSHA can contact you and say, show us your policy and show us what percentage of your workforce is vaccinated. And you have to have that on hand, ready to go. So it's a good idea to kind of get started with that at the very least. All right, so I want to, if we can, to the extent possible, kind of stick with the OSHA ETS first. We're definitely going to talk about the federal contractor rule because they're similar, but yet different. So when and I'll just say, like, one of the big differences is that if you are a federal contractor, weekly testing is not one of the options unless you have a religious or medical exemption. So when we're talking about the OSHA ETS, we're not talking about testing. We're just talking about vaccinations. And so, wait, did I just say that right? Or did I say that backwards? When we're talking about the OSHA ETS, we're talking about weekly testing. If we're talking about the federal contractors, we are not. See, that I just did it myself. And so we have a question, we have a question about the testing, home tests. So Vincent, do you know, if you get an over-the-counter test for COVID, does that count towards the weekly testing requirement?
So it could include a home test, but here's the thing. I'm going to talk a little bit about tests in general. What tests are acceptable? It has to detect current infection. Okay, so it can't be like an antibody test. It's got to be a test that detects current infection. It's got to be authorized, including emergency authorization from the FDA. And it needs to be administered in accordance with its instructions. But here's the key and the relevance to the question. It cannot be both self-administered and self-read unless it's being read by, for example, a telehealth provider. So a home test could work, but not if the employee is self-administering the test and reading the test themselves. If for the home test to qualify, it's got to be read by someone other than the employee. Not just any old random person either. The examples they use in the guidance is, for example, a telehealth provider or even observed by the employer.
Right. So, and I've actually personally done those kind of tests where you actually, you start with a home test, you connect to a proctor via Zoom, and you do the test on video, and then you put it in an envelope and you mail it to them. And so that's going to be one option. And then, like Vincent said, I mean, if you're going to do that type of test, another way to have that proctored is for the employer himself, someone from the employer company, observe that. You can't just do it completely privately on your own.
Right.
And so, Vincent, this was something we were talking about, you and I talking about at length yesterday. The other question is, does the employer have to pay for those tests?
Yeah, this is one of those hot potato issues too. And I know myself and lots of practitioners like me, I think you too, Diane, we've all struggled with this one. What I can tell you is that the ETS itself does not require employers to pay for the cost of the test. However, the ETS is clear that the employer may be required to pay if they're required to do so under some other law. So some examples of that, in California, there is a business expense reimbursement law that is very strict. I could foresee that kind of expense being covered by a law like that. I believe Kentucky has a law that requires employers to pay for any kind of employer required medical test. That's a specific state statute. I don't think we have something like that in Connecticut that I've seen. Diane, we talked about that one yesterday too. But also perhaps as part of the reasonable accommodation process. If an employee cannot get vaccinated due to a medical reason or a sincerely held religious belief, and as part of that accommodation process, they do the testing, it is very likely that an organization like EEOC and an agency like EEOC would say, hey, the employer picking up the cost for a test that the employee cannot do due to a health reason is certainly reasonable and could be deemed part of that reasonable accommodation. I can tell you that at this point, neither the Wage and Hour Division of the Federal Department of Labor, nor has the Connecticut Department of Labor opined on this topic. But I would be, notwithstanding that, I would be very mindful if you have a lower paid workforce or employees, folks who are at or near minimum wage, and considering what impact a mandated test cost would do. Would that put their earnings at below minimum wage for the week? That's certainly a consideration. I do know anecdotally that with regard to state employees, when the state implemented its vaccine/testing mandate, that they negotiated with CBAC, the State Employees Bargaining Coalition, for the state to pay for only a certain number of tests, but after that, employees would be on their own. So, I think this one, there's a little bit more room to be aggressive on it, but it's just not that perfectly crystal clear. And I don't take total comfort in the fact that the ETS says, hey, OSHA is not going to force you to do it. Because yeah, of course, OSHA is not going to force you to do it, but that doesn't mean DOL might eventually come out and say that it should be something that's covered by the employer. I don't know if you have more to add on that, Diane, because I know this is tough.
Just so that people understand. So the answer to the question, do we have to pay for testing? We don't know the answer to that quite yet. So that's kind of like the simple answer for now. I did actually speak to the director of the Wage and Hour Division of Connecticut's Department of Labor, and he indicated to me a couple of days ago that the Connecticut Department of Labor was hoping to issue guidance soon. I don't know what that means necessarily. So the agency that we're waiting for on this is the Connecticut Department of Labor for the most part. And so we need them to have an opinion on whether employers have to pay for the tests themselves and whether employers have to pay for the time it takes to do the testing itself. And so I can tell you that in my exchange with this representative from the Labor Department, his thoughts were that the Connecticut Labor Department would take a position that's most protective of employees on the one hand. That doesn't say anything necessarily for sure. And he also, for reference, gave me some information about the Fair Labor Standards Act, which is the federal law governing wages. And he pointed to information from the Federal Labor Department website that has said in the past that you do need to pay employees for the time it takes to take a test that the employer requires. And so this is one thing that Vincent and I were kind of debating with each other yesterday. I mean, this is not a test that the employer requires. This is a test that the government requires. And so we really just kind of have to wait and see, I think, and hope for more guidance from the Labor Department on all of this. But Vincent, you mentioned something yesterday, which I thought was a pretty interesting idea, and that was for employers to keep in mind that you can pay employees at different rates. And so if you have an employee who makes $25 an hour, typically, if you could pay them minimum wage to go get their test. You don't have to pay them their normal rate to get a test. So that's one compromise almost. If you were the type of employer that wanted to lean towards if you're risk averse and you don't want to take the chance of not paying anything, you could pay minimum wage. And of course there are downside, there's ups and downs to both of those. Your
Right.
employees will be angry, of course, but it may help to keep employees from just taking all day to get a test because they're only getting minimum wage. And so Chris, you popped on. Was there something you wanted to add to that?
Yeah, Diane and Vincent, one of the things we're hearing when we visit companies, because of the concern Vincent raised about the financial impact to the employees, and what you just raised, Diane, relative to the timing of it, a lot of the employees we're talking to seem to be leaning towards the pooling option. And Vincent, maybe you should verify whether that really is an option or not, but the reading of the ETS is that you could do a pooling antigen or PCR test, which is basically 5 or 10 employees get pulled together. As long as all of them are negative, you continue forward. Obviously, if something comes out positive, then everyone needs to disband, and you got to go back in and figure out who is that positive case. But those pooling tests are generally somewhere between $30 and $50, much lower cost, and the employers we're talking to are really looking to maybe pay for that so that there isn't a financial burden on the employees. And it's mostly companies that we've talked to who don't have a higher vaccination rate. Vincent, you mentioned, if you had a 70% or 60% vaccination rate, you're maybe at jeopardy of potentially losing some folks. If you're at a higher vaccination rate, then maybe you don't even want to do the testing, just go mandate the vaccine because you're so close to getting to 100%. But these are employers who are at a lower vaccination rate. They're worried about the cost of the employees of the testing, and they're also worried about losing employees because of the weekly testing requirements. And so they're a lot of discussion around pooling. So I don't know if you want to talk about that at all, if that's allowed, and the logistics behind it.
So I haven't worked with anyone who's doing that, but I just happen to have the FAQs in front of me, and just coincidentally, the FAQ on pooling was on that page. So I'm just going to talk about it. The question on OSHA's FAQs is, what is pool testing? And you've kind of described that pool testing can satisfy an employer's testing requirements under the ETS. Pooling means combining the same type of specimen from several people and conducting one antigen lab test on the combined pool of specimen. If the pooled specimen is negative, all employees who participated are considered negative. But to your point, if the pooled specimen is positive, you then have to do that individual testing to determine which one of those folks which one or more of them were positive. So it could have be a cost-effective alternative to it, but it could also be, administratively burdensome anytime you have more than, anytime you have a positive test come out of that pool. But hey, doing this in general is going to be administratively burdensome. So, I think it's definitely one of those, it's accepted. So the short answer is yes, it's allowed. And so it's definitely something to look at.
All right. I was just looking, we have a question about, are there any thoughts on if this will eventually include employers with fewer than 100 employees? My view on that is just based on, you may have seen a reference in the chat from CBIA that the ETS is nearly 500 pages long. Much of that is preamble, and it actually emphasizes that the reason why this only applies to employers with 100 or more employees is because those larger employers tend to have the resources that they need in order to manage something like this. They tend to have HR managers, lucky ones like you watching this, and they have the ability to do this type of testing and keep these types of records. So if I had to guess, I would say that it probably will not ultimately apply to smaller employers, but Vincent, do you have an opinion on that?
I generally would have agreed with you. I do generally agree with you. The only thing that gives me any pause is just the fact that Fifth Circuit focused on the use of that 100 number as being both overly over-inclusive and under-inclusive. And so I suppose it's possible to as part of trying to get around a legal challenge, I suppose it's possible that it gets modified, but I really don't see that happening. I don't see that happening. I'm more where I fall where you are, Diane, aside from that.
And Diane, I kind of try to touch on this at the opening. Because we have our own OSHA in Connecticut, OSHA, the state is required after the mandate goes into place, assuming it does, within 30 days to make sure the Connecticut standards are equal to or more restrictive than the federal. And so we've had some questions about, do we think the CBIA think the administration would require less than 100 to be governed under the Connecticut OSHA? And again, our discussion with the administration is not that we don't believe that would be the case. Nothing guaranteed, but the governor and the administration understanding that this is already burdensome to businesses. Vincent just mentioned the additional burden on under 100, and also with the labor shortage crises that we got going on, that could further damage some small businesses. So there's no indication that the OSHA would be more restrictive and apply it to businesses with less than 100 or have requirements above and beyond what the OSHA ETS already has.
All right, the next question, when an employer has a large cafeteria and we have unvaccinated employees, are they able to eat there when others are also eating?
Yeah, so it doesn't, the examples in the FA, the guidance doesn't address that specific question, but it does answer the question, what are the exceptions to the face covering rule for unvaccinated folks? Obviously, if you're alone in a room with floor to ceiling walls and a closed door, you don't have to wear it. But it does say for brief, limited time to eat or drink, and also to remove it for security identification purposes. And so I think the answer to that is yes, that they could take it off just for purposes of eating and drinking.
Okay. The next question, will this be applied to seasonal businesses and or employees?
Oh yeah, yep.
Part-time, full-time.
Yeah. So with regard to temporary or seasonal employees, if they're directly employed by you, then you count them for purposes of determining if you have 100 or more employees, but also for purposes of compliance, you have to make sure they comply if you're a covered employer.
All right, we have a question about outdoor employees, and this is going to be a time when I actually am going to talk about the federal contractor rule in comparison to the ETS, because the question is, what constitutes a fully outdoor employee? So Vincent, do you want to talk about, for purposes of the ETS, if you're a fully outdoor employee, when do you actually have to be vaccinated and when not for the ETS?
So the rule is supposed to be that you all practically, that your job is completely outdoors. And I never like to use the word never because never is too strong, but it's almost like you never are going indoors. There's, in some of the guidance, it says if there's regular, even brief meetings indoors, whether they be, I'm thinking of like a construction site and there's a brief morning huddle to go over things, and that's typically getting done inside, even if they're brief. I think that runs the risk of the person not being deemed an outdoor employee. I think there's a de minimis, a little bit of an exception for de minimis, like it's just very, very minor, having to enter indoors for very short, maybe just to use a restroom, that wouldn't negate the exception for working outdoors. But I actually think it's a tough standard to meet. It's a tough standard to meet for this exception.
Yeah, I think the information that I saw had that exact reference, that if you have to go inside briefly to a bathroom where there's more than one stall, but all you do is you go to the bathroom and you go right back outside, you can still be an outdoor employee and you won't have to comply with the rule. But other than that, that was kind of like the only example that would justify being exempt from the rule. And the reason why I wanted to just mention the federal contractor rule at this point is, Vincent, you can tell me if you agree, but my understanding is that the federal contractor rule is actually more strict than the ETS in this regard, because I think that the vaccination rules apply to federal contractors, whether their workplaces are outside or not, and whether the employees are working in their homes or not, even if they're remote. If they are working on a government contract, then they're a federal contractor covered employee. Is that your understanding?
Yes, it is. And that's why it's so important to understand if you're a federal contractor employer, because it is so much more strict than these rules. And that train is still on the track and it's still going. So
right. And I do want to talk about federal contractors, but I think I'll just set aside, unless we had a ton of questions about that, I'm going to set that aside for a little bit because I don't want to confuse people. And let's stick with the ETS for a bit. So we've got a question that says, we are a private golf course and only have 100 plus employees 3 months of the year. Will we need to comply? That's a good question. That's specifically answered by the FAQs, but that's a good question.
Yeah. So if you had 100 employees on November 5th, then you're covered. Even if you go under 100, and you're covered for the duration of the ETS. If you are under 100 employees on November 5th, you're not covered unless and until you hit 100 employees while the ETS is still in place.
Right. So if you're a golf course, so let's say you probably don't have 100 employees on November 5th, but it lasts for 6 months. So if you hit the 100 employee mark on May 1st, you are then subject to the rule. Is that right?
Yeah.
So if you're that golf course, you'll just have to wait and see. If you have 100 employees as of November 5th, then yeah, you're covered. All right, so what if there's a religious exemption? Wait a minute, can we, that's federal contractor. Let me just hold off on that for a second. We've heard that the test can cost between $90 and $110. Is that your understanding? Chris, did you have information on that or no?
Yeah, there was a recent analysis of the Connecticut testing costs, which actually were some of the highest in the country that the state was paying for testing under the CARES Act. And it does seem to range, Diane, between $100 and $130. So that is individual going to a center to have a PCR test, non-rapid, which is usually you get back within 24 hours. The PCRs are more expensive than the antigen. And as we mentioned, more expensive than the pooling. The pooling tests, my understanding of the companies that are doing them is costing about $30 per test for the pooling.
So that would not be the case for the at-home test that you get proctored, right? Like that's not, that's just the PCR, right? Okay.
Pulse PCR is there. Yeah, there are at-home tests. In fact, we have a member at CBIA called Detect. I could drop it in the box here, who is, I believe, the first in the world to have an at-home rapid PCR test. I believe it's charging about $40 per test. But to your point, Diane, and I think Vincent mentioned it as well, the reading of it needs to be different than the person administering of it. So that one, the individual can read it and administer it. So you'd have to arrange something with a healthcare provider. That one also gets stored on your phone. So if anyone asks you down the road, show me your test from 3 weeks ago, there's a storage feature with the QRT code. I'll drop the information or the link to that website on the right-hand side.
Okay. Now there's a question about pooling testing. I don't know if this is, I guess this question is kind of a follow-up to what we were talking about before. For the pooling testing, we're not, just in case you haven't had any exposure to this at all, so that is not a nasal test, at least in my experience. That has not been a nasal test That is a saliva test where you spit into a sample holder, and so does a group of people spit into this holder, and it's analyzed together as a group. Does anyone else, Vincent or Chris, do you have anything to add to that?
No, I just haven't. That's because I haven't worked with anyone who's used them, so I don't have direct experience with it, other than the stuff that we've kind of talked about here today.
I only know about it, to be honest, because my college kids did pooling testing, and their school, the college would test entire dormitories with this pooling testing, and so everyone on one floor or in one building would all spit into this one container, and that would be analyzed together. And if that was positive, they would gradually narrow it down by floor, then by area of floor, then by room, until they figured out who the positive test was. So I don't know if that's, if there's any other, Chris, do you have anything to add to that?
No, that's the way it's done, and a lot of the universities do the pooling again because they're paying for the cost, so it's a lower
Yep.
cost per individual, it's a lower cost overall versus if you go to the $130 cost per employee. That'd be very pricey, as Vincent mentioned, on both the individual and even on a very generous employer. It could get very expensive for, the ETS is good for what, 6 months, a test a week starting in January for a 6-month period of time. That's a lot of tests, 224 tests at $100 each per employee, $2,400 per employee. That gets expensive.
Yeah. Okay, so during the interview process, Vincent, can we ask if they are vaccinated, and can we deny employment based on the fact that they will not get vaccinated?
So normally the ADA would prohibit making a disability-related inquiry at the pre-offer stage, but the EEOC has made clear that simply asking about vaccination status itself does not violate that prohibition. So the short answer is yes, you can ask at that point in time. I don't know that it's always wise. My preference is to provide the information, as whether it be through the posting or even during the interview process, that hey, just FYI, we are a covered employer, or what, even if you're not, and if you just have your own vaccine mandate rule, expressing what that is to job applicants throughout that application stage. With regard to can you not hire someone because they refuse to get vaccinated, again, I think that better for that to happen post offer. Saying to someone as part of the offer letter that getting a vaccine is the job offer is contingent on getting a vaccine, subject of course to a medical or religious exemption. So yes, you could theoretically not hire someone because they refuse to get vaccinated, unless you can accommodate that if they have, for example, a medical or religious reason for not being able to do that.
Okay, so let's talk a little bit about the federal contractor rule. We have a question about subs and whether all the employees of a subcontractor would be covered by the vaccine mandate. So, Vincent, are you able to talk a little, like in general, what the general rules are for federal contractors, and then what are the rules for subcontractors as well? So
the big difference is that between the contractor rule and the ETS, like you said, there's no option that employers have to just unilaterally say vaccine or testing. Testing is fine. Well, we're fine with testing. That's not an option if you're a contractor, a federal contractor. And so who are, like, I'm trying to think of where to start here. So not every single, there's so much to start. There's you could get really lost in the weeds on all of this. But I'll also say not every single federal contract is subject to the contractor rules. Most of them are. Things covered by Davis-Bacon, for example, are contracts under Davis-Bacon clearly are. Contracts for services with the government are. One of the exceptions that I'm aware of is contracts for only the manufacturer provision of products themselves. That's one of the very few exempted federal contracts. But if you do, if there is a covered federal contract, then it is the contracting agencies, the government agency who's in the contract, it's supposed to be their obligation to insert language into the contract that mandates, that puts into place the executive order rules. And they do that with the prime contractor. And then the prime contractor is responsible for flowing down that requirement, that language, to each of their subcontractors who are working on that covered contract. And then those subcontractors are required to flow that down to any subcontractors of theirs who are working on that covered contract. So the flow down is supposed to go all the way down to where you get to simply the provision of product. And so with regard to, okay, fine, I've determined that I have a covered contract, whether it be as a prime contractor or as a subcontractor. Which are all of my employees covered by these rules? The technical answer is no. The only employees of covered contractors that are covered, hate to keep saying that word, are any employees who are working directly on the covered contract or subcontract, or if they're working in connection with the covered contract, and that could be in support roles, such as, in a lot of admin roles like HR, like billing, like purchasing, any jobs that support the company's ability to do the contracting work. So those folks are covered even if they're not working directly on the federal contract. But here's the third catch-all, and this is where I think it scoops up a lot of other employees. It could also cover any employees of that covered contractor, even if they're not working on or in connection with the covered contract, if they're working at a work site where other employees are working on or in connection with the covered contract. So I'm trying to think the example we talked about yesterday, Diane. If I have, I have a client who has their own workplace, they have their own facility, and they send a bunch of their employees, most of their employees, to their various customer locations in different areas. And so let's say that one of these employees regularly works on site at the customer location, but also at my client's location, goes back and forth on working on a covered contract with that customer. Then any other employees who work at my location are going to be deemed covered contractor employees for whom these rules impact.
Okay, yeah, so I mean, practically speaking, if your company is a federal contractor or a subcontractor, the chances are all of your employees are going to be covered, because you can either just work at the physical site of the subcontractor or contractor, or you just work in some way in connection with the contract itself, and it kind of scoops everybody up. I can tell you, so we did have a question about one of the FAQs about federal contractors, and Vincent, you probably don't have it in front of you, so I'll just tell you what it is. There was a question about when a covered contractor employee performs their duties in one building, and that contractor has lots of buildings, and in all the other buildings, the only people that work in those buildings are not covered contractor employees. Like, this is so specific, but it's like, if the member wanted to know, like, do those people have to be vaccinated if they're completely separate? And the answer to that is no, but the odds of those people being completely separate at all times every day is very low. And so if somehow you have an employee that's not covered by these rules, and they work all by themselves in one building, completely separate from everybody else, then that employee could probably be exempt. But I mean, the odds of that employee not interacting personally with anyone else, I think is kind of low.
Right.
But that was kind of the gist of the question.
Yeah, and back to the overall question about covered contractor employees versus not. There's two approaches, right? There's the splitting hairs approach. We're only going to do that. We're only going to mandate this. We're only going to do this for those who meet that definition, even though it's pretty broad, and we're not going to enforce it for the handful of few who may not fall into that broad definition. Or, and what I've seen more, I have a couple clients who have taken that approach. I think it's a little risky because if you screw it up, you're at risk of losing a contract. And for some employers, that is the lifeblood of their business.
Yeah.
The more typical approach is one saying, listen, we've got so many of our employees who are covered, we're not going to split hairs. We're just going to apply this across the board.
So just to confirm for everybody, to kind of summarize what all this information is about federal contractors. So you're the prime, you're the general contractor when you have the written agreement or verbal agreement with the federal agency. And then you're a sub if you have an agreement with that prime contractor, the general contractor. And if you're doing work that is required by that prime general contractor's contract with the government, you're a sub, okay? And so if you're a sub, then all your employees, pretty much, generally speaking, all your employees are going to have to be vaccinated because you also have a contract that's referring to the government contract. And then also, I just want to confirm one thing that Vincent said, because this applies to a lot of CBIA members. If you are a manufacturer, and let's say you're a subcontractor, but the only thing you do is you manufacture and provide products, you are exempt from this rule unless you provide services. If you service your products, you're covered. But if the only thing that you do is manufacture the product and ship it out, even if that product ultimately goes to the federal government, manufacturers, if that's the only thing you do is manufacture, you are exempt. Okay. All right. So let's move on. Vincent, we've got a question about religious exemptions.
Mm-hmm.
What if there's a religious exemption regarding federal contractors? Do we need to test? Because normally you wouldn't be testing. What does the audit of this order look like and an evaluation of the exemptions granted?
So it's not, if let's say you're a federal contractor, you're a covered federal contractor, and you have a covered contractor employee who presents with a religious accommodation request, and assuming that it's legitimate and it's granted, assuming that it's granted, do you have to require testing? No, but that is certainly one of the possible reasonable accommodations that can be provided for someone to be exempt from the vaccine mandate. Frankly, it's probably one of the accommodations that I see used most often in those exemption situations. I don't know what the audit process will look like, but I do know that I've recommended that employers who get these requests develop a form that gets used so that you can evaluate this kind of in a consistent way. And it could include questions like asking an employee who's requested a religious exemption to identify what their sincerely held belief is, to identify how that belief conflicts with receiving a vaccine, asking whether they oppose all vaccines or just this one, and why or why not. In you know, having that and maintaining that document would help support you if you were audited by your contractor or your government agency. I think that goes a long way to showing that you did evaluate it and that your decision was based on a legitimate exemption request. I don't see the question anymore, so I don't know if I missed part of the question.
No, you did. I think that the one thing I think maybe the person asking the question perhaps thought there was a different rule for exemption requests for federal contractors versus the ETS. But do you agree it's really kind of the same process for both? That's one of the ways they're actually similar.
Yeah, I think that's absolutely true. And I've actually talked about it with a client before and I told them, you know, you don't have to do the testing. There are other accommodations that you could provide. But if the reasoning behind all of this is safety and trying to keep COVID out, you know, I think that you know, this is one of those double-edged swords. I think it would be a no-brainer if we knew that we're not responsible for the cost of the test or the time to go get the test. I'd say it's a no-brainer. That should be your default that should be a default position if you're able to grant an accommodation in this case. The only thing that I've seen that's held some people back is, well, there's this open question kind of about, you know, whether that puts the burden of cost on the employer. Nevertheless, I'd still say in the vast majority of clients I've worked with, they have been doing the testing as an accommodation for someone who can't get the vaccine under the contractor rules.
And then I guess if the testing was cost prohibitive, or if the employer wasn't interested, if they have an employee with a valid medical or religious exemption that prevents a vaccine, if working from home is an option, that would be one way to accommodate them. And again, so these rules regarding accommodations, they're the same, whether we're talking about federal contractors or the ETS. This is what we've been talking about for a year and a half now, really. It's all this has to do with discrimination law and just whether you have to accommodate someone because of their religion or their disability or medical issue. So that nothing has really changed there. So let's talk a little bit about staffing agencies. The question is, if we have a temporary employee employed by an agency, how should we require vaccinations?
So I think this one is really under the OSHA rule. And if you have temp employees at your facility, but they are still employed directly by the temp agency, then it is the temp agency's responsibility to count that person for their for purposes of counting whether they have 100 employees or not. You would not count them toward your calculation of whether you have 100 employees or not. And then aside from that, if the temp agency does have over 100 employees, it's their obligation to abide by the vaccination testing rules. You're not, as the host employer, not responsible for complying with the testing and vaccine requirements for those temp employees who are who are directly employed by the temp or staffing agency. If and when the employee becomes directly employed by the host company, at that point, it would be the host company's obligation to do that.
All right, I had a related question that came in a while ago from a staffing agency, and it kind of highlighted for me how people are mixing up the federal contractor and the ETS. And the question had to do with, they were saying, we're a staffing agency. We work with companies we provide employees to companies that have more than 100 employees. We don't have 100 employees, but the people we work with have more than 100 employees. So we are complying with this rule. And that's, do you agree with me? That's a bit of a misunderstanding there.
Yes, they don't, and it's nice that they are, but if the staffing agency itself doesn't have 100 employees, they don't need to abide by the ETS for their under 100 employees.
Right, so so let's say you're a staffing agency and you have fewer than 100 employees. It doesn't matter who you work with, you do not have to follow this ETS with the vaccination rules. But if you're a staffing agency and you happen to be a subcontractor on a federal contract, then it doesn't matter how many employees you have. The issue is that you're a subcontractor, and then you do have to follow the vaccination rules.
Yeah.
Actually, we have some members with that exact issue. So that's how that came up.
Yeah.
Okay. Vincent, Vincent or Chris, do you have any opinion on boosters and the likelihood of boosters becoming a requirement to be fully vaccinated?
I know that it's on the table, but it hasn't been done yet. But if you look at the headlines, these headlines with this Omicron Delta or this new variant, I think it's a little bit more like, I think it's more likely than I did a few weeks ago that it may wind up becoming part of the fully vaccinated definition. But obviously that's conjecture. I don't know that for sure. I'm just trying my best to read the tea leaves.
Chris, what do you think? Have you heard anything?
I agree. Yeah, Diane, I would agree 100% with what Vincent said. I've told folks if there is any area where Connecticut maybe would get more restrictive in the Connecticut OSHA, it would be on boosters. We're one of the lowest states in the country when it comes to boosters. We just went over 6% today on the infection rate. And the governor likes to err on the side of caution. So if there's anything that Connecticut OSHA would do to be more restrictive than the federal, I think it would be eventually including boosters in it because of where we are right now. So when folks are doing the roster, my recommendation would be roster those who've been vaccinated, those who aren't vaccinated, those with the exemption, and roster boosters as well. More and more people are getting the booster with the percentages going up.
Did you just say we're one of the lowest states for boosters?
Right. Yep.
Oh,
In the country.
So disappointing. Okay, so Vincent, this is pretty detailed, but let's see if you know the answer to this. So you know how with the ETS, you have a requirement to provide information to employees, and there's a specific CDC document that you're supposed to provide. And so if you click on it, it links to a lot of other things. Do you know if you're in compliance if you just provide the first document, or do you have to provide all the linked documents as well? I don't know the answer to that, but I would guess you only have to provide the first link.
That's exactly my guess too, because I've not gone to that level of depth on that issue, but that's certainly that would be my understanding too.
Okay, the answer about subcontracts, the question about subcontracts, we already answered for the provision of products. And I don't remember, Vincent, do you or Chris, maybe you touched on this. So does a rapid test actually comply with the testing requirement? Because those were less reliable, weren't they at one point?
As long as it's PCR antigen, the FAQ is really more about the type of test, not the speed to it. So as long as the one I dropped in the chat is a rapid PCR. Rapid tests have a tendency to come back with more false positives, which could then cause more people to potentially have to leave the workforce for a period of time. So folks should be aware of that. The Detect one actually has a lowest number of false positives, but it just needs to be antigen or PCR.
All right, so we are actually at the end of our 90 minutes and we've hit all the questions. Vincent or Chris, is there anything else that you guys wanted to touch on?
One thing I would just say generally, this is really hard stuff. We're learning this stuff every day. It's changing every day. There have been situations where a conversation I had with a client a few weeks ago, that advice might have changed based on these developments. So just be mindful of that and patient with that as you're dealing with, you know, your HR resources or, you know, counsel or even service providers like CBIA. But it is worth consulting with folks like us, because as you can see with all this overlap, it's easy to think you're out, but you can easily be in because of something you weren't even thinking about, like that one of those contractor ETS examples that you used, Diane. But aside from that, thanks for having me. This was a lot of fun.
All right, and we'll continue to post Q&As on our website about this. We had a recent one maybe from last week that talked about federal contractors and federal subcontractors, and we'll continue to do that. Chris, was there anything else that you wanted people to know before we end?
Yeah, I think just the most important thing for businesses, Diane, is something that Vincent mentioned early on, which is understand your culture, understand where you are with your vaccination level, because you know, if it's doing nothing and mandating vaccines, and there's a lot of stuff in between. So people just really need to understand their culture. If they got high vaccination rates already, maybe you don't even want to do the testing option. Just go, you know, vaccine only, and don't even wait for the OSHA if you're at 98% or 95%. If you're low vaccination rate and your culture is really anti-vax, then you're going to want to think about the testing option. Maybe you want to think about pooling, but you really need to gauge your culture right now, get your rosters in place, and think about what kind of plan you want, a vaccine only, a vaccine with testing, and that can be done while this whole litigation process is happening.
Okay, so let's end it there. Thanks everyone for joining us, and we will see you next time at our next hotline. Have a good afternoon, everybody.